How well do college students know their rights? Taking a survey of some people around our college campus, we found out only a quarter of students can name the 5 rights guaranteed in the First Amendment, while half knew the date the Constitution was adopted. Clearly, the First Amendment is important enough to have more people know about it. The First Amendment came to life in 1789 when the Bill of Rights was adopted by the House of Representatives. Included in the Bill of Rights was the First Amendment, which says, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Freedom of speech was first given in the Greek city of Athens between 800 and 400 BCE. Speech in the early days, in Athens, in England, and even in the United States, was restricted to only the higher classes and government officials. You can see the problem with that. Eventually and gradually, the freedom of speech spread to lower classes. A major point in the development of free speech is 1215, in which King John was forced to sign the Magna Carta, the basis of liberty in England and the United States. It declares that justice was not to be sold, denied, or delayed, and that no free man could be deprived of life or property except by pure judgment and the law of the land. Speech, however, was not absolute. It was still controlled from libels like sedition, defamation, and blasphemy. Though not all of these restrictions continue to exist, we constantly find ourselves in a dilemma in what speech we should allow and what speech we shouldn't. Many philosophers had ideas about free speech before and after the First Amendment. One important philosopher was John Locke, an important philosopher in the Age of Enlightenment. He theorized on why mankind is willing to give up the absolute freedom given to them by nature. He said that when mankind is completely free and every man is his own king, there is continual danger and uncertainty. Thus, this makes him willing to quit a condition which, however free, is full of fears and continual dangers. And it is not without reason that he seeks out and is willing to join in society with others who are already united or have a mind to write for the mutual preservation of their lives, liberties, and estates, which I call by the general name property. In other words, we compromise in order to work together to protect the things we value. John Stuart Mill, a British philosopher and a strong proponent of individual liberty, wrote in his book, On Liberty, if all of mankind minus one were of one opinion, and only one person of the contrary opinion, mankind would be no more justified in silencing that one person than he, if he had the power, would be justified in silencing mankind. Mill's ideas were influential in the creation of the First Amendment and how the First Amendment is interpreted by the courts. Some ideas included the prevention of the tyranny of the majority, allowing everyone to have an equal opportunity to express their views, no matter how few people believe in it, how one should never interfere with the pursuit of happiness of another unless it begins to affect another in an undesirable way, and in the end, freedom of speech will lead to the gradual and eventual discovery of truth. Now it has been centuries since the First Amendment. As stated previously, the First Amendment has seen its fair share of controversy. To solve these controversies, our country has turned time and time again to the Supreme Court. The Supreme Court set precedents in how the First Amendment should be interpreted in specific situations. Knowing the major Supreme Court decisions is important as these decisions have incredibly heavy influence over all future cases. Starting with speech in schools, here are the major free speech controversies and decisions of our time. What can we and can't say inside a school? As most of us can say from personal experience, schools can indeed make their own rules to preserve the learning environment. But the question is, how far can they go? The precedent for the controversy over student expression would be Tinker v. Des Moines. In this case, when 3 public school students protested a school board ban on protest activities by wearing black armbands in opposition to the Vietnam War, they were subsequently suspended, but they took action. In this landmark Supreme Court decision, the court decided that the armband is a form of symbolic expression and that teachers and students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gates. How dangerous does speech have to be in order for it to be restricted? The levels of severity of speech that is allowed has changed over time, starting with bad tendency. Bad tendency meant that the courts could restrict speech that, well, had a tendency to be bad. However, that definition was a bit broad and over-restrictive, leading to some changes. The case that replaced bad tendency was Schenck v. United States. Schenck was convicted of violating the 1917 Espionage Act by circulating an anti-draft leaflet. The Supreme Court upheld the conviction, creating the clear and present danger clause, which stated that speech must present a clear and present danger before it is punished. The clear and present danger clause was used until Brandenburg v. Ohio in 1969, in which a Ku Klux Klan leader was filmed talking about revengeance against certain groups in a march to Washington on the 4th of July. He was convicted because he presented a clear and present danger. However, in reversing the conviction, the Supreme Court decided that speech must not only create a clear and present danger, but must be likely to produce immediate lawless conduct. Besides being dangerous, speech can also be defaming. Defamatory speech is usually split into two types, slander and libel. Slander would be speech that is fleeting, like in conversation. Libel would be permanent or far-reaching speech, such as speech that is published or broadcasted. In the United States, most defamation suits are civil, which are done for monetary damages in civil court as opposed to criminal court. The landmark case in defamation law was New York Times v. Sullivan in 1964. In this case, the New York Times published an advertisement supporting civil rights activists in the South, but also referenced the alleged misconduct of police in Montgomery, Alabama. L.B. Sullivan, a former supervisor of the police department, sued for damages and was awarded $500,000. In a landmark decision, the Supreme Court reversed, creating the actual malice rule, stating that statements had to be made with knowledge that the information was false and used with reckless disregard for it to be defamatory. However, the actual malice rule was updated in Gertz v. Welch when attorney Elmer Gertz was accused of multiple falsehoods, including having a criminal record and being a communist fronter. Eventually, the Supreme Court decided that private individuals like Gertz need more defamation protection as they lack the tools for rebuttal, and that the actual malice standard does not apply to them. A major part of speech that society in the past has sought to restrict would be blasphemy. Nowadays, the controversy is no longer with religion, but with morals. Most people are familiar with the Scopes trial, a highly publicized trial about the teaching of Darwinism in public schools. However, the Scopes trial never made it to the Supreme Court, and therefore never set a precedent. The legal equivalent of the Scopes trial would be Epperson v. Arkansas. In this case, biology teacher Susan Epperson challenged the 1928 Arkansas anti-evolution law. The Supreme Court unanimously decided that no level of government can censor the teaching of scientific fact and opinion in public schools because they conflict with religious beliefs. Now onto obscenity. The Supreme Court has had two landmark cases over obscenity. The first is Roth v. United States. Samuel Roth was convicted of mailing obscene advertising. In upholding the conviction, the Supreme Court created the Roth test for obscenity, which is as follows. 1. The work is worthless or has no social importance. 2. The work is sexually lewd, by this definition. To the average person, with community standards applied, the dominant theme of the material appeals to prurient interest. However, in 1973, the Roth test was replaced by the Miller test. In this case, Marvin Miller was convicted of distributing advertising brochures containing sexually explicit illustrations. The Miller test took out the definition of the average person and added the SLAPS test, which tested if the work lacked serious literary, artistic, political, or scientific value. Another type of speech that the people have sought to ban would be fighting words, or words spoken in a face-to-face confrontation that are likely to create an immediate breach of the peace. The fighting words doctrine was created in Chaplinsky v. New Hampshire, but has been edited to create distinction between free debate. In Chaplinsky v. New Hampshire, Walter Chaplinsky, a Jehovah's Witness, created a disturbance by disturbing the literature of his sect while saying organized religion was a racket and calling the city marshal a goddamn racketeer. He was convicted by New Hampshire law, and when appealed, the Supreme Court unanimously upheld, but also created the fighting words doctrine, which is defined as words that inflicts injury upon the listener and tends to incite an immediate breach of peace. Afterwards, the fighting words doctrine saw some revisions, as it was seen to be too broad. In the case Cohen v. California, Paul Robert Cohen was arrested for walking down a corridor in the Los Angeles County Courthouse wearing a jacket with the words, "After draft." The Supreme Court reversed his conviction and revised the fighting words doctrine to just to incite an immediate breach of the peace. Later it would find one more revision in Gooding v. Wilson to become the final version, words spoken in a face-to-face confrontation that are likely to create an immediate breach of the peace. The Supreme Court has decided many precedents on many controversial circumstances. However, even today we run into free speech issues at every corner. For instance, should the Nazis or the KKK or the Westboro Baptist Church be allowed to speak as they please? One controversy would be free speech zones, which was created because of unwanted protests. These zones can be seen as efforts to maintain peace while allowing free speech, but they can also be viewed as censorship. Sometimes the time, place, and manner are part of the message. The Supreme Court has ruled in Snyder v. Phelps that what Westboro said, in the whole context of how and where it chose to say it, is entitled to special protection under the First Amendment, and that protection cannot be overcome by a jury finding that the picketing was outrageous. By Justice Roberts. Hate speech is just one controversy. Another controversy that affects us all would be the Internet. On the Internet there are low entry barriers, no gatekeepers, it is hard to control, and it is boundless. Moreover, users can be easily anonymous. From the Internet arises issues like cyberbullying. When one is anonymous and speaking on a computer screen as opposed to a live human being, it becomes far easier to say hurtful things. In recent years, many teenagers, notably teenager Megan Meyer, have committed suicide due to cyberbullying. The Internet has also allowed an easy avenue for breaching of copyright, most commonly seen in illegal downloading and streaming of copyrighted content. Many have called for strict copyright restrictions like SOPA, the Stop Online Piracy Act, but others think that these acts breach the First Amendment. Another piece of controversial legislation would be the Patriot Act. This act was passed in response to 9/11 and aimed to prevent terrorism. However, some people believe that the Patriot Act infringes on privacy along with many other individual rights. Of course, we would want increased safety, so how do we effectively balance the values of safety versus privacy? And what about the privacy of politicians themselves? As we have seen, many politicians meet their downfall in scandals about their personal lives. Do politicians have a right to privacy, or should they, as public officials and public figures, forego that right? Recently, we took a survey to find out how college kids feel about key issues concerning freedom of speech. We found out that 87% believe that people of all ethnic and social backgrounds have equal rights to speak. 72% believe that politicians have the right to keep their private lives private. 43% believe that flag burning should be protected. 32% believe that the Westboro Baptist Church has the right to protest funerals. Only 5% believe that the news is fair and unbiased. Out of the First Amendment rights that they can name, freedom of speech was the most popular, followed by freedom of religion. Free speech is one of the foundations of America. There is a reason why it is in the very First Amendment in the Bill of Rights. There is a constant urge to protect this freedom. However, speech can, at times, interfere with our other rights, as detailed in this video. There is a fine line between what we consider acceptable and what we do not. Does speech need to be absolute as possible like Voltaire says? Or is our obsession with permitting speech damaging victims of certain types of speech as McKinnon believes? Accurately make a decision and voice your opinion.